Forensic issues of ethanol. The use or abuse of ethanol is associated frequently with medical legal implications and consequences. Alcohol abuse is prevalent worldwide. Efforts have been made to totally prohibit alcohol consumption in different countries without much success, with the possible exception of those countries where law is in force. Such attempts usually lead to illicit brewing and consumption with even more serious or consequences. At present in India, total prohibition is forced only in the following states: Gujarat, Bihar, Mizoram, Nagaland, as well as the Union Territory of Lakshadweep. Efforts to implement the same in other states have met with a dismal failure. All over India, except where prohibition is in force, the mere consumption of alcohol and consequent drunken behavior in themselves does not constitute any offense. Only when the drunken individual behaves in such a manner as to become a public nuisance or possess a threat or actually commit an act endangering the life or the property of another person or even his own, will the law take cognizance of the fact. Drunkenness. First point. A doctor is sometimes called upon by the police to examine an individual who was taken into custody for creating public annoyance in a state of intoxication or for driving a vehicle under the influence of alcohol, for being involved in a criminal offense after drinking. In such a case, the doctor must exercise great caution before coming to a conclusion. He must first be familiar with the exact meaning of the term drunkenness. An individual can be certified to be drunk only when there is evidence that he has so much under the influence of alcohol as to have lost control of his faculties in such an extent as to render him unable to execute safely the occupation in which he was engaged at the material time. The essence of this definition is that the doctor must much search for evidence indicating that the individual concerned was under the influence of alcohol. The smell of ethanol in the breath, the pulse rate, the agitation of people, color of the face gave no indication of the degree of intoxication. The conclusion regarding this must be arrived at after a detailed examination with a special reference to the state of mind, coordination of movements, visual acuity, etc. As in every medico legal case, before embarking on the physical examination of the individual, the doctor must first obtain his written consent. This must be tempered by the fact that if an individual really is drunken, then he is probably in no fit medical condition to give or refuse consent. In such cases, the doctor can proceed with the examination but should not divulge the result or his conclusion until the individual has sobered up and provides valid consent. However, if there is any implicit direction from a judicial court to divulge the results without delay, the doctor must comply with such direction. If an individual refuses consent is uncooperative, the doctor can proceed with the examination without bothering about this formality. If the former has been arrested for a criminal offense and is under the custody of police section 53(1) CRPC, but the requisition in such a case should have been issued by a police officer not below the rank of a sub-inspector. The doctor can conduct not only the physical examination of accused but can collect the samples of the urine or blood for analysis. Next is sometimes the question is asked when it is proved that a person has consumed alcohol as to how much he could have drink, the quality of liquor consumed. To answer this question, two facts must be known: the blood alcohol concentration, the nature of alcoholic beverage taken. If these are known, an estimate can be made as to the minimum quantity of liquor consumed by consulting. A rule of thumb is that every ounce of an 80% proof liquor will raise the blood alcohol concentration by 35 milligram percentage. It is one peg of a distilled spirit or one glass of wine or quarter to half of beer. Average elimination rate is 115 to 20 milligram percentage per hour. Before employing such a data, however, it must be borne in mind that the calculation relating alcohol ethanol consumption to blood alcohol concentration are the outcome of a statistical generalization, but may not be applied to every individual case. Moreover, they are often based on laboratory experiments which may be at variance with the clinical setting. Added to this is the fact that a person who is drunk may not remember accurately as to what type of liquor he had consumed nor the quantity imbibed. Even if he does, it is likely that only vague pronouncement would be made, such as 3 glasses of wine or 5 packs of whiskey. Experimental studies have demonstrated that a glass of wine could refer to a volume varying between 76 and 134 milliliter, depending on the nature of globet and the person who is pouring. It is also clear that the percentage of alcohol is highly variable in different brands of wine. This could mean that one person's glass of wine can contain as much as twice or even 4 times the alcohol of another person's glass. Similarly, the problems are experienced in the distilled spirit. A peg may refer to a volume of liquor which varies from 20 to 60 ml. How measures of the whiskey poured at home are usually double the quantity that are given as a single whiskeys in the public bar. As an alternative or supplement to blood alcohol concentration, the level of alcohol can be estimated in the urine alcohol concentration. To calculate the blood alcohol concentration from the urine alcohol concentration, multiply the latter by 0.66, which gives a rough estimate. For example, if the urine alcohol estimation is 100 milligram percentage, the blood alcohol concentration would be 100 into 0.66, 66 milligram percent. It is to be noted, however, the first sample of urine voided after the individual has taken into custody by the police must not be used for analysis, since there is a likelihood of erroneous interpretation. Urine sample will contain very low concentration of alcohol even after heavy drinking. The person had started consuming alcohol when his bladder was already containing urine. On the other hand, a very high concentration will be obtained if he had emptied his bladder and then commenced drinking heavily. Therefore, the person should be asked to empty his bladder, and then a second sample is collected after some time, which is used for analysis. Ethanol and crime. Broils, assault, sexual and non-sexual homicide, suicide are commonly associated with intoxication. Even if the assailant was so drunk that he had lost control over his mental faculties, therefore was not in a position to judge whether his actions were right or wrong, he is still punishable for any criminal act committed by him. 86 IPC, unless the alcohol was administered him without his knowledge against his will. 85 IPC. Ethanol and traffic accident. It is well known that consumption of ethanol and consequent intoxication has adverse effects on the driver of a vehicle in the form of a visual blurring, motor incoordination, impairment of judgment, and increased reaction time. The Law Reform Commission Report number 4, issued by the Australian government in 1970, secondly correlates the blood alcohol concentration with the driving impairment as follows. Blood alcohol concentration up to 50%, a driving ability of most individuals is unaffected, although there may be slight impairment in some individuals. Blood alcohol concentration 50 to 100 milligram percentage, most people are affected, very degree. Blood alcohol concentration 100 to 200 milligram, there is severe impairment of driving ability with increased liability to accident. Blood alcohol concentration over 200 milligram, there is high likelihood of an accident. Thank you.